Michelle O'Neill. So the answer to the first question, how I got into family law, really I didn't choose family law chose me. Whenever I graduated from Baylor Law, I was 23 years old. I went through Baylor on their 3-3 program, and I did it in 2.5 and 2.5. And by the way, anybody that thinks that that means I'm smart, no, it means I'm stupid, because I should have stayed in school longer. And so I'm 23 and out in the world at a time when the practice of law was going through a major recession. Texas was going through a recession. The oil and gas industry had trickled down to the savings and loan industry, which had trickled down to all the big law firms, and there were no jobs to be had. And my choices were to go to work like some of my colleagues as a paralegal, or go back home to my hometown, which is Belton, Texas, and open up a law office. And so that's what I chose to do. The day I passed the bar, at the time, Justice Raul Gonzalez from the Texas Supreme Court was eating a hamburger in my mother's burger restaurant in Salado, Texas. He found out I'd passed the bar, and he said, well, let's swear you in. And I said, not over the burgers, you're not. So he invited me to a meeting he was at that night and swore me in before the meeting. And that same day, I signed a lease on my law office that was a little 10-by-10 room. And I had a computer and a room, and I started practicing law. And being 23 and looking about 12, there were a couple of kinds of cases that would hire me. One was criminal defense appointments because they had no choice. The second was juvenile defense appointments because they had no choice. And the third was family law. And I thought family law was the greatest thing ever because it was the thing that on a Friday when I needed money to pay the rent, somebody inevitably would come in carrying 5 crisp $100 bills. And it was awesome. And I knew the answer to the question, and I'd take their case and I'd go with it. So it more chose me. I got into LGBT issues a few years ago because of my appellate practice. I was referred a case that ended up being very prominent in the local Dallas media and some national media, but case involving a lady who was an emotional parent and not a legal parent. And I took her case to the Dallas Court of Appeals and ended up winning it eventually, and on standing issues, which we'll talk a little bit in a while about the difference between standing and suing. And because she is an activist in the LGBT community, she allowed me to take the case to the media and get some press and public attention on it to help others that are similarly situated to her, which then kind of launched my little subspecialty in LGBT custody issues.
Mr. Cole?
Thank you. My name is Dave Cole, and I went to Pepperdine School of Law, and there was a professor out there that I particularly had a relationship with, and this was 1985, and there was a huge case out there called the McMartin Preschool Molestation case, and it was really the first big case where the interviewing of children who were making allegations of sexual abuse was really challenged. And the professor that I was working for was a consultant for the Los Angeles District Attorney's Office, and I was working for him at the time, so I just got into those issues. When I came back to Dallas from law school, I wanted to work at the District Attorney's Office, and I got a job there and did child abuse for about 7 years. Many of the children that that find themselves in those situations where they are removed from parental custody for reasons of abuse and neglect, many of those children are placed for adoption. So when I left the District Attorney's Office, I had done a lot of termination of parental rights work. And I just then, sort of the natural progression in private practice is adoption work. I never really got into LGBT. It just kind of, we represent folks who want to adopt, and that includes evangelical Christians and LGBT and everybody else in between. So that's how I got into it, and have enjoyed it immensely. I think it's a really amazing
know what the current state of the law in Texas is concerning divorce and property divisions, and perhaps what are some unique challenges that an LGBT couple might face in a community property state such as Texas?
You skipped a question, but that's okay. Before I get to your question, I've got to share with you, well, all of us have our phones going up here. I do have a schizophrenic practice. I do entertainment law and family law, and one of my entertainment clients has just posted something on Facebook, and tell you the connection in just a second. He's a speaker and a writer, and he's in, I guess, this month's issue of Details, and his name is Randy Potts. He's Oral Roberts' gay grandson. He's been in the news on the networks and whatever, and Randy is a client of mine. He just posted this, now it says 1 hour ago. It says, so I bet Keaton, who is his fiance, bet Keaton today that our marriage, which will be in New York in May, will be legally recognized here in Texas within 10 years of our wedding. The loser has to dress in drag and cook a big old meal of crow. The thing is, I think we're both secretly hoping to lose. I'm having lunch with Randy and Keaton tomorrow to go over exactly what we're going over here today. So this is kind of a rehearsal for what I get paid for tomorrow at lunch. So,
Are you billing today?
I'm sorry?
Are you billing today?
No, I'm not. But I will be billing more. The answer as to what the status is here in Texas is real simple. None of the above. None of it is recognized here in Texas. Texas has both the Defense of Marriage Act and it is also a part of our Constitution. How long is that going to stay that way? Nobody knows. We really don't know. As you mentioned, out in California, Proposition 8 was just found unconstitutional on very limited grounds by the Ninth Circuit. That happened last week. The Washington state that you listed as one of the states that recognizes marriage, it was signed into law the day before yesterday. Also, the day before yesterday, the New Jersey Senate passed a gay marriage bill. It's expected to pass their assembly, which would be Texas House of Representatives, but it's also expected that Governor Christie is going to veto it. I read today that the votes in the Senate were not enough to override a veto, but who knows? Washington, I believe, is the second state, maybe the third, that has actually passed it not through legislation as opposed to the Supreme Court making a ruling as to the constitutionality. Also, on the other coast, on the East Coast, are two fascinating cases going on that are currently in the First Circuit, and they're being considered together. One of them is the state of Massachusetts versus the State Department, the U.S. Department of Health and Human Services. Their argument is this: Massachusetts, of course, recognizes gay marriage. The position of Massachusetts is we do not have two statuses, two classes of marriage. You're either married or not. The federal government, because all states, of course, are the ones who implement federal legislation. The federal government, because of its Federal Defense of Marriage Act, requires Massachusetts to create two classes of marriage, and therefore that is a violation of equal protection. There's a case real similar to that, the Guild case, which is in, I believe, Washington, D.C., where a couple got married, and they're arguing over federal benefits, also attacking the Federal Defense of Marriage Act. So you've got a case on the Ninth Circuit on the West Coast. You've got the two cases in the First Circuit on the East Coast, and then we have Texas. In Ray J.B., which is the case that began out of Dallas here, in which a couple were married in Massachusetts.